Hate crimes, as a legal category, represent a contrived construct devoid of historical or conceptual legitimacy, emerging not from enduring principles of justice but from modern legislative innovations that impose subjective interpretations on criminal intent. For millennia, societies adjudicated offenses based on the act itself, assault, theft, or murder, without the overlay of motive-based enhancements tied to bias or prejudice. This absence of crimes against hate, or bias-motivated offenses, allowed communities to maintain order through objective standards, unburdened by the need to probe psychological dispositions. Prejudice and bias, as innate human faculties, shaped social interactions without inviting state scrutiny, enabling individuals to navigate threats and alliances intuitively. The introduction of such categories disrupts this equilibrium, transforming ordinary crimes into amplified penalties contingent on prosecutorial discretion, which inherently favors selective enforcement over uniform application. Discrimination, similarly, existed as an unregulated facet of human decision-making prior to mid-20th century interventions. Societies operated without federal mandates prohibiting racial preferences in private affairs, viewing them as extensions of personal sovereignty. Employment, housing, and associations proceeded according to individual judgment, fostering self-reliance and group cohesion absent legal compulsion. The shift began with statutes in the 1960s, which codified prohibitions against discrimination in delineated spheres, ostensibly to rectify imbalances but effectively curtailing autonomy. These initial measures, targeting public accommodations and workplaces, marked the inception of a regulatory framework that escalated incrementally. Subsequent expansions compounded this intrusion, layering protections for additional attributes and broadening jurisdictional reach. What commenced as targeted reforms snowballed into comprehensive oversight, incorporating housing and educational domains, with penalties escalating for perceived violations. This progression, engineered through successive amendments, entrenched federal authority over intimate choices, eroding the distinction between public obligation and private prerogative. The design facilitated unchecked growth, as each iteration justified further encroachments under the banner of equity, transforming isolated provisions into an expansive apparatus that permeates daily conduct. The architects of these laws, often aligned with ideological agendas, crafted mechanisms prone to subjective interpretation, where intent becomes a malleable criterion wielded by authorities. Enforcement varies by jurisdiction and context, permitting outcomes that reflect prosecutorial bias rather than impartial rule. This subjectivity undermines the rule of law, as penalties hinge on inferred prejudice rather than tangible harm, rendering justice arbitrary and vulnerable to manipulation. Societies endured millennia without such constructs, relying on communal norms and direct accountability, which preserved social fabric more effectively than imposed uniformity. Prejudice, as a cognitive heuristic, served evolutionary purposes, aiding discernment in uncertain environments without necessitating statutory intervention. Bias informed alliances and exclusions, bolstering resilience against external pressures. The imposition of legal barriers against these faculties disrupts natural hierarchies, compelling conformity that weakens collective defenses. Discrimination, far from aberration, functioned as a safeguard, allowing groups to allocate resources and affiliations strategically. The 1960s legislation initiated this erosion, compiling disparate prohibitions into a cohesive edifice that ballooned through judicial gloss and administrative fiat. This snowball effect, intentional in its architecture, proliferated through iterative statutes that layered obligations, each building on prior foundations to normalize intrusion. What began as narrow curbs on commercial practices evolved into pervasive surveillance of motives, outpacing original intent and entrenching dependency on state arbitration. The result is a regime where prejudice incurs disproportionate sanction, inverting traditional justice by elevating sentiment over deed. Communities thrived under prior paradigms, unencumbered by the need to dissect every act for underlying animus, demonstrating that such laws introduce fragility rather than fortitude. The fraudulence inherent in these formulations lies in their detachment from objective criteria, substituting empirical harm with speculative grievance. Liars and subversives, through rhetorical artifice, advance these measures to dismantle established orders, embedding provisions that invite exploitation. The subjective lens they impose ensures uneven burdens, where certain expressions of bias provoke condemnation while others evade scrutiny. This duality exposes the law's discriminatory core, as they empower select interpreters to enforce selectively, perpetuating cycles of favoritism disguised as rectitude. Ultimately, the absence of hate crime paradigms across history attests to their superfluity, as societies adjudicated transgressions through unadorned facts, preserving liberty from inquisitorial overreach. Discrimination's unregulated status facilitated adaptive behaviors, unhindered by the regulatory sprawl that now encumbers choice. The 1960s onset, with its foundational statutes, catalyzed an inexorable expansion, compiling restrictions that snowballed by deliberate design to consolidate control. This trajectory reveals a subversion of foundational liberties, where self-preservation yields to mandated inclusion, and prejudice faces erasure under pretextual equity. The enduring viability of pre-modern systems underscores the artificiality of these constructs, which, in their subjectivity and overreach, betray the principles they claim to uphold. Societies flourished without them, guided by innate discernment rather than legislative fiat, affirming that such laws represent not progress but erosion of sovereign judgment.